Hey guys, what is up? RedPandaMining here, back with another video. Guys, I'm going to talk about Quadriga CX, and they had an update on their website today, so let's get into it. February 5th, 2019. Dear customers, today an order for creditor protection in accordance with the Company's Creditors Arrangement Act, short-term CCAA, was issued to allow us the opportunity to resolve outstanding financial issues that have affected our ability to serve our customers. We did not enter into this decision lightly. For the past weeks, we have worked extensively to address our liquidity issues, which include locating our very significant cryptocurrency reserves held in cold wallets required to satisfy customer cryptocurrency balances on deposit, and sourcing a financial institution to accept the bank drafts being transferred to us. Unfortunately, these efforts have not been successful. Since we were unable to resolve these issues in a timely fashion, we did not want trading to continue on our platform. We filed for creditor protection to help resolve these matters and preserve interests of our customers. With this filing, the court has appointed a monitor, Ernst & Young Incorporated, an independent third party to oversee these proceedings as we make every effort to address our customer obligations. Filing for creditor protection allows us to work diligently through the process and try to ensure the viability of our company. We are sure you have many questions. We are in early stages of a long process, and we do not have all the answers right now. What we can tell you is that the CCAA process will allow Quadriga CX to keep all options open to attempt to maximize the funds available for the company's stakeholders. We will provide further updates to the extent possible. Included below is a Q&A, which we hope will address some of the questions you may have at this time. Quadriga CX values and appreciates all of its customers and employees. We thank you for your support and understanding during this challenging time. A copy of the order issued by the Supreme Court of Nova Scotia on February 5th, 2019 may be found here. Alright guys, so let's go through the Q&A. What does it mean to file for creditor protection? Filing for creditor protection occurs when a business needs time to figure out how it will meet its debt obligations. Next question. Why are you filing for creditor protection? Once it was apparent that we could not access significant cryptocurrency reserves held in cold wallets required to satisfy customer cryptocurrency balances on deposit, nor obtain the funds to settle customer currency withdrawal requests, we made the tough but necessary decision to file for creditor protection. Makes sense. Is there a chance that a solution can be reached to settle customer withdrawals? Over the past weeks, we have worked extensively to address our liquidity issues. As such, we are operating under assumption that the solution will not be reached in the near term, which is why we have filed for creditor protection. How long will the protection remain in place? Creditor protection is in place for 30 days with the option to extend. Why can't you access the coins in the cold wallets? Cold wallets, by their nature, are highly encrypted and were kept off the Quadriga server for security reasons. Jerry Cotton, the CEO who passed away, took sole responsibility for handling of funds for Quadriga CX, and as such, no one other than him can access the coins in the cold wallets. Again, no one other than him can access the coins in the cold wallets. What steps have you taken to access the coins in the cold wallets? We have hired outside consultants to access these cold wallets. To date, we have accessed a few coins, but not many. Work on that front is ongoing. Okay. Will you opt to extend creditor protection? Our focus right now is the initial 30 days and determine the plan on how to deal with our customer obligations. Why go through this process when you can just file for bankruptcy? Creditor protection was necessary to protect the interests of our customers. We are exploring a number of options to settle our customer obligations. Well, that's nice. Will the website ever be back online? We have taken the website offline while Quadriga CX is in the CCAA process. It is expected that all account balances on the platform existing as of the date of filing will be dealt with through the CCAA process. Together with the monitor, the company will determine if it is feasible to restart the website and will seek the court's authorization to do so if appropriate at a later date. Can I still access my trading history and account information even though the website is inactive? Each customer's trade history will be preserved. Next question. Who can I contact with regards to the status of Quadriga CX's CCAA process or make a comment? Answer. Ernst & Young, that's the monitor, is appointed by the court as an independent third party to monitor the proceedings and can be contacted at quadriga.monitor@ca.ey.com. What a domain. Will you provide a further update? We will provide further updates to the extent possible. Public materials filed in relation to our CCAA administration will be available via Monitor's website at www.ey.com/ca/quadriga. Take that all in, guys. Take that all in. So I hope that will answer a lot of questions and worries. They're doing all they can. They're doing all they can right now, and they're doing it through legal means. And I feel like that's the best they could do right now. And we'll have to wait and see what happens. Okay, next, guys. I have a Twitter post, a lot of Twitter posts that I want to go through and read. I haven't read through them yet. There's a reporter, Mr. Jack Julian from CBC. He was at the courtroom today at Quadriga's in Nova Scotia at Quadriga's court hearing for the CCAA. And I'm just going to read through them all and let's indulge them. Let's see here. All right, so Jack Julian, 14 hours ago of making this video. He says, I'm at the Quadriga hearing. The widow of Jerry Cotton is not here due to safety issues, but she's available if need be for cross-examination on her affidavit. Man, I don't know how to say that word. Next tweet. There has been widespread suspicion online that there is some sort of nefarious activity involved in Jerry Cotton's death in India and the apparent loss of US $190 million in cryptocurrency locked in his encrypted laptop. This hearing is to provide creditor protection for the Quadriga under Canada legislation for companies owing more than $5 million. The CCAA stay of proceedings would protect Quadriga for 30 days from its creditors who want to collect. Next tweet. Lawyers here say they represent people who are owed over $10 million in missing crypto. Wow. So there are some people there being represented that owe $10 million. Wow, Jesus. The judge was concerned about all 115,000 Quadriga clients being informed before any protection order is made. But since none of the lawyers objected, it's moving forward to discuss the scope a potential stay order. Lawyers for creditors like the idea of a laptop which perpetually, I can't say that word, holds the cold wallets with as much as 180 million in crypto will be secured by court-appointed lawyer. Apparently, lawyers for Quadriga are finding more money all the time. They got word last week of a bank that may be holding 11 million in Quadriga funds. All right. The laptop was now in possession of Quadriga's lawyers in Toronto. Waddell Phillips. It was being examined by an ex-RCMP computer expert. Nice. It is now being transferred to lawyers acting for creditors to eventually be placed in the hands of a court-appointed monitor lawyer. Lawyer for Quadriga says there may be as much as $180 million of crypto floating around out there that haven't been found. They haven't found. Quadriga hopes that by getting 30-day stay of proceedings, they can find these assets to the extent that they exist. Quadriga wants to do this in an organized fashion, providing information from people testifying under oath. Hopefully that is more reliable what you find in a chat room. Indirect dig at Reddit. Huge indirect dig at Reddit. I mean, honestly, this is so true. Hopefully that's more reliable than what you find in a chat room. Okay, yeah, I wanna divulge in that because this Quadriga CX2 Reddit thread post, whatever, second Quadriga CX is a laughing stock. All these people making up conspiracies and stuff, they just don't know the actual information yet. We don't know. We don't know until this actual court hearings happen. RCMP getting involved, all the legal proceedings getting involved. This is how we're supposed to do it, guys. Don't just hide behind your computer and type out whatever you think is happening. It's just brutal. Anyway, going on, Quadriga has no office and no bank account. It only exists on a piece of paper in their business registry in BC. 25 million of Quadriga funds were released from Ontario courts after freezing action by CIBC was overruled. Those funds are held in third-part payment processors such as Billerfly. $5 million were held by various New Brunswick companies. Lawyers for Quadriga now control those funds, will be used to pay for bankruptcy proceedings and negotiate a possible sale of Quadriga trading platform to satisfy debts. Quadriga hopes to find all the wallets and make people whole, but that's for some other day, far into the future. Justice Michael Wood, that's the head justice guy, I guess, wants to know what Quadriga's ongoing expenses are. The answer, costs of storing and protecting the data from the website, even though it isn't live right now. Expenses for experts who will go find the cryptocurrencies. All right. Quadriga is not a company with a full set of accounts, so there will be costs associated with determining what is exactly there. We are in a 15-minute break. Oh, this is going to be a long one, guys. There are around 20 people in the public gallery, courtroom 503, mostly reporters, some lawyers out of professional interest, an NSCC professor who teaches about financial crime because of cryptos used to launder funds, not because he thinks there's evidence of crime in this case. Court is back in session. All right, we got a photo here. Maurice Chazon is the lawyer for Quadriga CX. I asked if he would be speaking to reporters. He said probably not, which is, to my optimistic ears, remains a slim yes. We have plenty of questions, obviously. Next tweet, lawyer for Quadriga. There are coins that are now being found and need to be stored somewhere. Lawyer Maurice Chazon wants authority to set up a wallet to hold coins and communicate the contents to stakeholders. Judge says it's better for court-appointed monitor to have control of the wallet because it needs to be examined and monitored for interested parties, and that could be onerous. Here's an example of Quadriga's bookkeeping services. These are apparently bank drafts. According to Chazon, they are now off the stove. Nice. Wow, look at that. Bank drafts on the stove, right in their office. What a legitimate... Jesus Christ. All right, moving along. Artier shot of the Quadriga financial stove. Red candle remains unexplained. Oh my God. Wow. That looks like a really old stove as well. Did they not? They didn't have an office? I thought they did. They had an office in Vancouver. That's really strange. Moving along. This is really long, guys. I'm sorry. But I want to get through the whole thing. Discussion about how to alert potential creditors. Chazon suggests Globe and Mail, but now they are talking about posting notices on Reddit. Oh my god, the Monitor is actually explaining subreddits to the judge, and they are discussing which subreddits would be appropriate to post notices to creditors on. This is a good day for Nova Scotia justice. Wow, alright, Reddit. Alright. I mean, I think that's okay if they're gonna post just notices, that's fine. But I hope they don't take information from there, because there's a lot of crap on there. Discussion of privacy interests of crypto holders. Quadriga lawyer wants the Monitor to compile a list of names of crypto holders and amounts of emails, but he doesn't want to make it public. Judge wants to know if the crypto holders have the onus to prove why it shouldn't be disclosed. Quadriga would rather keep that client list private unless someone can put forward an argument such as a list should be disclosed. He says Quadriga always protected the privacy of clients, and this is an extension of those efforts. Yes. Quadriga lawyer says once you let the genie out of the bottle, you can't get that privacy back. I would imagine that many Quadriga clients valued their privacy to extreme extent. Usually publishing a list of creditors would be standard. It's an interesting question. The CCAA order will include posting a notice to creditors in a subreddit to be announced. That's hilarious. I wonder if they know what a worm can that is. Yep. Quadriga's website will remain shut down until the order from the court in order to achieve some stability. Approximately 100,000 Quadriga users, also described today in court as 115,000 users. Lawyers mentioned there's a lot of anger looking to find a home in this case. Typical lawyer understatement. That was probably on Reddit. Monitor proposes creating a website and hotline to interface with stakeholders. Yeah, I mean, you can use Reddit, I guess. Maybe not. Quadriga's website may be used for communication, but for that initial term, it will be a Monitor providing information to shareholders. Okay, going back, Monitor proposes creating a website and hotline interacting with stakeholders. That right there is a thing to get people's IP addresses and names and all that jazz. So email, all that jazz. So be careful of that if they're going to make a website. Monitor says that the most important step to achieving stability for Quadriga and notifying creditors, clients. Monitor says a bankruptcy of a crypto exchange is a rare event. There are examples from Japan. Monitor raises possibility of creditors challenging whether Canada is the right jurisdiction to handle this bankruptcy. She notes that $5 million in bank drafts anchors this matter in jurisdiction, plus Quadriga is a Canadian company, but she suggests leaving this process open to arguments for a change of jurisdiction. The Monitor says it's an unusual role here because of a locked cold wallet, not a typical bankruptcy. Counsel for creditors, this isn't a typical CCAA, not the restructure of a steel mill. We are dealing with cash and cash equivalents. This lawyer represents 78 clients owed over $11 million. The Monitor must be made the custodian of any encrypted USBs, laptop that might hold the missing crypto. He thinks couriering the laptop to Nova Scotia to Toronto is extremely risky. Why would you courier a laptop that may hold the secret to where $216 million is Canadian? The lawyer for creditors wants Ernst & Young to take control of the laptop in Toronto and order anyone holding property that belongs to Quadriga to surrender it right away to the Monitor. Anonymity of the holders is important. It's the equivalent of publishing the contents of somebody's cash accounts. Maintaining the anonymity of clients and creditors makes sense for now. That could be revisited. The wallet the Monitor sets up will be a cold wallet to protect and preserve assets. Justice Wood is satisfied an order under CCAA should be issued today, including the stay. Wood says the court does have jurisdiction, that Nova Scotia is the correct filing jurisdiction. He wants to reflect on the details of the order he is going to take a break, but has the drafting questions. Under the Act, the stay will last for 30 days, giving Quadriga protection from lawsuits and associated deadlines during that time. Judge will listen to the thoughts about who should be the representative counsel for the many plaintiffs. He expects many lawyers will say they are the best place to handle the claims creditors. Creditors might be $500 creditors, might be multi-million-dollar creditors. Lawyers for one of the set creditors wants the matter of representative counsel to be settled as soon as possible. Judge has no time today to address this. Could be settled this Thursday, judge says. What about next Thursday? What's the urgency? Judge says, while it's important for the voices of investors to be promptly reflected, it's important not to rush in a complicated case. It makes sense to have a reputable counsel assigned by the 30-day comeback date of March 7th. Clients, lawyers. There is a lot of confusion right now. This is like nothing we've seen before. This is a case about $260 million gone missing, with tens of thousands of people in chat rooms trading information and threatening potentially officers of the court. Adjourned until 2 p.m. Atlantic time. No comment from the monitor or lawyers until after 2 p.m. Back in session. Deadline for submissions to court February 25th about possible extension of stay, etc. A report from the monitor will be submitted March 1st. Judge is finessing wording of various clauses of the company's creditors arrangement act order. Lawyers will meet together and mark a draft copy. Judge Wood says he'll issue it this afternoon. The judge says the issue representative counsel is not urgent enough to rush the timeline. There will be a hearing on that on 09:30 on February 14th, Nova Scotia Supreme Court. Judge says if anyone wants to make a motion that this will be taken care of on an expedited basis, he'd like those applications in on Friday. And that was the last tweet from Jack Julian 10 hours ago. Oh, all right, guys. That's all I'm going to go through, and hope you guys indulged all that information, what's going on with Quadriga at the moment. Let me know what you guys think down below. Please like and subscribe, all that good stuff, and I'll see you guys tomorrow in the next video. Have a good one.